Hello everyone, welcome back to my channel, and in today's video I will be dealing with the establishment of High Court. So what we have seen up till this point now is basically that how East India Company acquired India and made it its colony. Then slowly, as the judicial system changed from point on point, then again in Adalat system in Bengal. So from Adalat system, then there was Sadar Adalats, then Nizamat Adalats and all. And through the Regulating Act of 1773, as the history progressed, and the Charter of 1774, the Supreme Court was established. Now what happened was, Supreme Court was also existed, and these Diwani Adalats were also there. This Adalat system in Bengal was also there. So due to this reason, slowly, due to their conflict, there were emergence of high courts, and the entire topic of discussion today will be revolving around how high courts were established from its first instance to till independence. So let us begin. First, basically, we need to understand what are the causes due to which high courts were established in India, or what was the need basically of establishment of high court. So the first and main reason why high courts were established in India is basically there was a dual judiciary or dual system existed at the same time. As we have seen between various different types of cases, that is Kausi Jura case, Rajananda Kumar case, Patna case. So these landmark cases that were happening at the time. So basically some of the cases were happening because there was a conflict between the company courts, that is Adalat system, which was existed in India, and then again a crown system, which was the Supreme Court. So there is a conflict between Supreme Court, that is crown courts, and company courts, that is Adalat system. So again there is a conflict of jurisdiction between the same. Supreme Court says that they have the original jurisdiction for the matters, they had the writ jurisdiction, whereas on the other hand Adalat system conflicts and says no, we have that jurisdiction. But then again, if certain matter is there, certain conflict is there, which court shall the person go? Other court will object, which is the reason why both of the system were abolished and a new high courts were established, which replaced the existing Supreme Court and Adalat system. So the main objective was to abolish this dual judiciary. At the same time, a new judicial system was to be established through this High Court Act of 1861. Then again, who were presiding? First, Chief Justice and Puisne judges. Chief Justice and Puisne judges were presiding over the high courts, and also a key feature of this High Court Act was in each presidency of the East India Company, each presidency there was one high court. So mobility part was also been properly dealt with. Then qualification for the judges, they have to be barrister and practice at least for 5 years experience. They should have 5 years of experience from Britain. And next, or either they have to pass the civil convenant service exam. So basically civil convenant service exam at that time resembles to our UPSC exam that is existed today. So basically a person who has to be judge, he has to have these two qualifications. Mainly he has to be a barrister and practice for 5 years. Along with that, he has to pass the civil convenant service exam. Or a Jilla judge can become a High Court judge if he has 10 years of experience. So these were, or if both of these qualifications are satisfied, then a judge can be appointed. Then again, these were the qualifications and objectives of the High Court Act. Then again, what was the jurisdiction of the high courts? So high court basically, after the abolishment or after replacing, not abolish but replacing the Supreme Court and Adalat system, the entire plethora of jurisdiction was given to high court. So civil jurisdiction, criminal, admiralty, testamentary, instate, matrimonial, original, appellate, all of these jurisdictions were given to High Court. So it has enlarged jurisdiction of the entire India. And then again, the appeals which were existed from High Court, the appeals from High Court went to Privy Council directly to Britain. So this was the entire structure of the High Courts. But there again, we have seen from time to time how again everything that Britishers have done in India was basically based on trial and error method. Not a single time it had happened that they had done something which was 100% correct. Then again, here also demerits are there. In every single instance the British had worked, there were demerits. So again, here also in the judicial system. So first we will see about the judicial system, that now we have seen the establishments of high courts. Further on, as we progress in upcoming videos, we will see about the legislation or the legislature system at that time. So judicial system, high courts, replace Supreme Courts and Adalat system. In legislature, again, Government of India Act is there, Indian Council Act is there. Then again, developments of these acts are there, which replace the previous system and establish an entire new system. So again, coming back to the point, the demerits of jurisdiction of High Court or the High Courts Act of 1861. First, it was very biased in nature. So if we look at the appointment of judges, what we see is that only British people were favored. Again, favorism comes into play. Then again, only English persons were allowed to become judges. Discrimination against Indian judges or Indian people. Then it was only in presidency towns. So this is a key and major problem with the High Courts Act of 1861. As for example, up till this point, we have seen that there are almost 5 to 6 presidency towns. Bombay, Madras, Kolkata, Bengal, Bihar, Odisha, and along with that Patna and 6 other towns were presidencies. But what about other towns which do not have a high court? They have to, each and every time they would have to travel and visit the jurisdiction of which the high court is there from these presidency towns. Then again, mobility part will come in the demerits. So these were the demerits of the High Courts Act of 1861. But then again, High Courts Act also got an amendment, or another High Court Act was passed in the year of 1911 itself. So after a 30, 35, 40 years gap, this High Court Act was passed in the year of 1911. So basically what it did was increase the number of judges for a speedy disposal of the case or quick justice. Then again, additional powers were given. So what happened was, in 1861, Governor and General was there. He had more power than judiciary. If he want to counter or reverse the decision of High Court, he can do that. But then again, here Governor General was again given more authority which he had prior. So here in this case, we see that there was no independent judiciary, though judiciary was for the name only. Then additional powers were given to justice. And then again, as we progress towards the independence era, in the independence era, many states or many cities specifically, there were high courts for various reasons. Few of them are, first there was in Punjab in the year of 1948, just after partition, an order was issued and a provisional high court was established for the time being in Punjab. Next, in Assam, it was again for the provisional constitution. According to the provisional constitution, the high court was established in Assam, and also accordingly in Orissa and Rajasthan. Then again, in Kerala, the high courts were established by issuing an ordinance, because at that time there were so many cases that immediately the establishment of high courts, the need of high courts increased at the time of independence, the main reason being the partition. So in Kerala also high court was established. Apart from that, by issue of a patent letter by the then federal court or Supreme Court. Later it will be renamed as Supreme Court, but first it was federal court at the time of independence. In Jammu and Kashmir also a high court was established. Apart from that, many cities were there in which high courts were established. And the thing is that Britishers throughout their regime, changing the judiciary from time to time. We have already seen, first East India Company came, East India Company exercised their own matters in their own hands. Then Crown again interfered in the judiciary system of the East India Company. Then again conflict was going on and forth, and the Indians were the ones who suffered due to their conflict. And then again, here we come after Regulating Act of 1773 and Charter of 1774, Supreme Court and Adalat system, again the same thing. Supreme Court from Crown interfering with the Adalat system which the East India Company had established. Again there was conflict and the entire system was abolished and a new high courts were established. And we will see from time to time how the federal and the executive structure got changed from the Government of India Act to the Indian Councils Act. Basically these two are main bodies of acts which establishes the legislative and executive structure before the time of independence. And with this I have concluded the topic of High Courts Act of 1861 and establishment of high courts. Thank you.